Here.
Vice Chair Miguel Martin.
Present.
Board Member Art Gala.
Here.
Board Member Maurice Capro.
Here.
Board Member Karen Owens. Board Member Debbie Pankey.
Here.
And Board Attorney Amelia Ulmer.
Here.
Sorry about that. Anyway, Miss Owens had requests to be excused. She had told us that she wouldn't be able to make it.
Okay. Thank you. All right, can I ask that we all stand for a moment of silence? Rabbi Capro, can you lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right. Deputy Chief, we'll let you stand before you sit down there. Do we have any changes tonight?
Good evening, everyone. No changes tonight.
All right. Do we have a motion to approve the agenda? All in favor, say aye.
Aye.
Okay. Anyone giving testimony this evening, please stand and be sworn in.
Okay. If you could stand, raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right. Informational, we, 3 cases, all in compliance. We won't go through them individually, but that's correct.
Correct.
Nice job. And another great report. I saw that cases initiated were about the same, but open cases are down a couple to 72, and we're down to 1 from 7 for cases, code board cases, rather. Thank you. Good job, guys.
Thank you.
All right. Has anyone reviewed the minutes from the regular meeting on June 24th, 2025?
Chair, I have reviewed and make a motion to approve as provided.
Do I have a second?
I second.
Kristen?
Board Member Gallo.
Aye.
Board Member Capro.
Aye.
Board Member Pankey.
Aye.
Vice Chair Martin.
Aye.
And Chair Gilday.
Aye.
Thanks.
All right, that brings us to the first case, 500. New case, sorry about that.
For the record, Chris Albon, Code Compliance Inspector at the City of Winter Springs. I have been sworn. I request this presentation and testimony be submitted as part of the official record. The first agenda item to be heard, case number 2025 CE000665, for the property located at 898 Gary Hillary Drive for violation of Florida Building Code Section 105.1, permits required. Under Florida Building Code, Section 105.1, permits required. Any owner or owner's authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any impact-resistant coverings, electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be performed, shall first make application to the building official and obtain the required permit. Case summary. On April 16, 2025, I arrived at the reference property to post a stop work order notice based on information provided by Bobby Coleman, City of Winter Springs building official, regarding construction alteration being performed at the reference property without applicable building permits. Observed construction materials on the site at that reference property during the inspection, Exhibits 1 through 5. Exhibit 1. Exhibit 2, the construction material outside. Exhibit 3. Exhibit 4 is the stop work order notice posted. And Exhibit 5. On April 16th, 2025, notice of code violation was sent to the property owners and registered agents by USPS certified mail with return receipt requested. On April 22nd, 2025, the notice of code violation was delivered to the property owners. On June 3rd, 2025, I conducted a reinspection of the reference property and found that the property remained in violation. I conducted a permit check which revealed that permit number commercial 2025-0343 had not been issued and required a resubmittal for corrections, and permit commercial 2025-0307 had a hold placed on it. Exhibits 6 through 10. Exhibit 6, the reinspection of the stop work order still posted. Exhibit 7. Exhibit 8. Exhibit 9 of the property. And Exhibit 10. On June 3rd, 2025, notice of hearing was sent to the property owners and registered agents by USPS certified mail with return receipt requested. On June 10th, 2025, notice of hearing was delivered to the property owners. On July 10th, 2025, I conducted a permit check which revealed that permit commercial 2025-0343 had not been issued and was in review, and permit commercial 2025-0307 remained on hold. And as of yesterday, I did a permit check for the property, and it still showed that the permit status remained the same, that permit commercial 2025-0343 was still in review, had not been issued, and then permit number commercial 2025-0307 remained on hold. Staff recommendation: staff recommends the Code Enforcement Board find the property in violation, issue an order requiring the violation be corrected and the property brought into compliance on or before August 21st, 2025, which would be 30 days, and consider the imposition of a daily fine of up to $250 per day in the event the requirements of the order have not been met by the date set for compliance by the Code Enforcement Board. What that means is obtaining the permits. That concludes my presentation. Does the board have any questions?
What kind of communication have you had with them?
So between myself and community development, we've had a good amount of communication with the tenant, and then as well with the property owner. The property owner's been notified that there's work being performed without a permit. The tenant's aware of that as well. Tenant's been making the applications, but the work has continued even without the permits being issued.
Any input at all as to why they're continuing the work without the permits, or?
I could not comment on that.
Okay,
Mr. Chair.
please.
Officer Elbon, why, in general, why would the city permitting department place a hold on a permit?
Let me, if I could bring up Tara Lynn.
Or specifically, why is there a hold on this permit?
Was she sworn?
Yeah,
Oh, we
just real
need to-
quick. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? I do. Thank you.
Thank you. Can you state your name?
Good
and
evening. For
position
the record, Tara-Lynn Roll, Director of Community Development. The main reason we'd put a permit on hold is if there is another permit that supersedes that needs to be approved prior to that permit. But in this case, there are some permits that have been submitted, but there are comments from all reviewers that the applicant has not yet addressed.
Okay.
So it's not on hold. The applicant has not addressed the comments, and so the review is not moving forward.
Okay,
May I ask a follow-up?
please go ahead.
How long have those comments been posted, and how long has the respondent had time to reply?
I don't know the exact duration, but it's been a couple of weeks.
Can you speak to the extent of those comments?
No, I don't have those handy.
Okay.
Did we provide those to code? But I can provide those.
Okay.
They're just review comments, and if the applicant doesn't address them, then you can't close it out or resolve or move forward.
Okay.
Yeah.
I do have another.
The applicant is
You have it,
aware.
Art.
Yeah, has the applicant discussed the comments with the city at all? Do you know?
Yes, so after the applicant was informed that they were doing work without a permit, they submitted the permit. The applicant, on 2 occasions, has met with city staff, one time, most recently with the community development staff, including the building official and the applicant's general contractor. So the applicant and their general contractor was aware prior to finalizing submissions with the application as to what was required. So some of those requirements have not been met, in addition to other comments by the reviewers that have been unaddressed by the applicant for about a couple of weeks now. I could provide at another time the exact date those comments were issued.
I have a question. Let me start with the attorney. To my understanding, a stop work order is a legal notification that is enforceable. Am I correct?
Yes, that's correct.
All right. Then my question comes, if there was a stop work order posted by the inspector and work continues, what happened or what has happened and
So beyond sending notice to the property owner, that's kind of the only recourse we have at this moment, and that's why it's being forwarded to the Code Enforcement Board.
Well,
May
my initial question
Yes.
was if they had a GC, and if the GC pulled it, the GC has a license.
Right.
The GC is performing work without a permit on a license. That license can be in jeopardy.
Absolutely. I mean, that's my concern. I mean, if there's a stop work order, there has to be a way of enforcing a stop work order.
Florida Department of Professional Regulation, FDPR, license complaint.
Can that be done?
May I just provide some
Sure.
additional information to the
Please,
board?
please.
So after a stop work order is issued, the applicant may come to the Community Development Department, submit the permit, and there's certain work that can be done prior to the first inspection. So as I said, the applicant submitted an application, not the property owner, but the tenant. And there were certain requirements that had to be met. So that's why staff met with them to make them aware. They have since hired a general contractor, so that general contractor is certified with the city and attached to the application. And I actually just got a message from our community development manager that our building official, as recently as today, has spoken with the engineer for the project. One of their pending items is to provide signed and sealed documents, which haven't been submitted yet. So we have been in communications. They have done the work that they're allowed to do, probably more, but they are allowed to do certain work. They have the permits in, but they haven't met all the requirements for the reviews to be completed nor have resolved all of the comments.
Would they be able to resolve all the issues with the city within that 30-day window by the 21st of August, I think it was?
Well, as soon as they submit signed and sealed documents from the engineer that our building official spoke to as recently as today, it's possible, yes.
Okay. A question for Officer Elbon. I noticed that there were multiple notices mailed out.
Correct.
I think I counted 4. Why?
So they get mailed out to the property owner with their mailing address as based in the property appraiser's record, the tax collector's record, and then in the event it's a corporation, it's to the registered agent and to the mailing address for that LLC.
So this is kind of to make sure that the notice gets received by the
Correct, by
respondent.
by all parties involved. Now, in this case, it doesn't appear that the registered agent received those, but the property owner has received the notices, so we've met due process requirements for that.
Do you feel that they're trying to work with code enforcement on this, or it sounds like it's being difficult to me?
I really wouldn't be able to comment too much on that. Right now, we're just looking at, as far as for a code compliance standpoint, it's work without a permit and just trying to work with the property owner and utilize the tools that we have available to get this in compliance and the permits issued.
As far as being in compliance, can I just ask you to clarify? We just heard that the certain things were able to be completed up to the point of the permits in question being awarded. You've clearly noticed or observed that work in excess of what was allowed to do has been completed?
So the previous building official, Bobby Coleman, he's the one who has firsthand knowledge of the work that was being performed. And that's how I was notified by him that there was work being performed and required a stop work order. So as far as having firsthand knowledge of what was being performed at that property, I didn't observe it myself.
I see you shaking your head.
Yes,
So
sir.
you're able to confirm that they
Yeah.
have gone beyond the scope of what they were permitted to do?
Yes, Mr. Coleman was the previous building official. The current building official, Mr. Glenn Perino, the Community Development Department, have all confirmed that they've gone beyond the work
Beyond.
that is allowed
Okay.
to do.
I just wanted to be certain of that.
Yeah.
Thank you.
So that brings up the question that I asked before. If they've gone beyond the work that they're allowed to do, what action, if any, has the city taken or does the city intend to take against them for violating that stop work order?
So we're not pursuing right now a violation of the stop work order. It's just a violation right now of the Florida Building Code as adopted by the city's Code of Ordinances. That's why there's a stop work order that's been posted, and we're requesting giving that 30 days. So if they're in the event that permit's not obtained, then we could potentially start imposing fines of up to $250 per day to attempt to get some voluntary compliance out of that.
Then what's the purpose of the stop work order? I don't understand why we post stop work orders if we do nothing with them when they're violated.
I wouldn't be able to answer that right now.
Council, can I ask a question? Are we, as a board, allowed at this point to make a suggestion in our motion to City Council that if by the date that we set for compliance is not met, that the city makes a complaint against the on-file general contractor?
I think at this time, given that the stop work order itself is not before the board, just the work without a permit, that might not be appropriate at this time, just to rule on specifically the permit violation and that make a motion based upon that.
But a licensed contractor is performing work knowingly without a permit. That to me seems
Right.
counterintuitive to a licensure.
Deputy Chief, may I ask you? Sorry to make you get up.
Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
Thank you. I understand that you may be more involved in the process with the stop order and how it would proceed if we were to
Right, as
enforce
Inspector
that.
Eldon stated, it's kind of a separate issue. Before you tonight is the issue of no permit under Building Code 105.1. That's where we're seeking the board to make a decision on. The stop work order is another route that we can take and are taking, but we're not in a position to present that to you at this time, or may never be, to, take action on that. We understand the licensing requirements and things like that. My understanding is the GC's coming in kind of on the later end, to try to sort this out. So ultimately, our goal is compliance. So we hope that by this general contractor coming in now and being able to sort it out, and, with action from the board to motivate the tenant to come into compliance.
Understood, and not trying to drill you, but for our own edification, in the normal process of doing business, if you issue a stop work order, how do you normally proceed, or when do you say enough's enough? If channels don't work through
Well,
enforcing?
typically it comes before the board for the original violation. The stop work orders don't really hold any criminal proceedings to it. It's all licensing and things like that.
Okay.
Yeah, there's no, it's.
I was just hoping that you could kind of lay down what the ground
Yeah,
rules were.
it's not as, it says stop work order, and as long as they don't remove them, they keep them posted there. If they're continuing to do work, they're still violating the city code of for
Understood.
whatever it was originally.
Yeah, it sounds to me there's a number of steps the city could choose to take. Right now, the step is, we're choosing to take is to get them in compliance. And I think if that doesn't work, then there's the next step, whatever that happens to be.
Correct, and like I said, my understanding is the GC's coming into this and kind of in the middle, if you will, and not at the initial point.
Okay.
So I guess that's a point of clarification I need. Was the original application filed by the tenant, the owner, or the contractor?
The tenant,
Okay.
yeah, the initial.
The initials, okay. I don't have any more questions unless anybody else. Thank you.
You're welcome.
I'm ready to, I can make a motion.
Is there a respondent? You need to ask if there's a respondent.
Is there a respondent that was supposed to come tonight or that's here?
You need to put on the record that's.
Okay. Nobody?
I received an email from the property owner stating that he may be here, but doesn't appear to be that way.
Okay.
All right, that's too bad.
Yep.
Okay, Mr. Chair,
How about it?
I'll make a motion. I move to find the photographs and testimony of the code officer, Christopher Elbon, clearly show there is sufficient support to substantiate the issues present with the property as it relates to a violation of Florida Building Code, FBC, Section 105.1, permits required, in order that the respondent be given until 21 August 2025 to establish compliance. In the event that the violation is not corrected, a fine of $250 shall be imposed per day per violation until compliance is reported to and verified by city code enforcement.
Any
I'll
further?
second.
I'll second that.
Okay, any further discussion?
I have a question. Can we shorten that 30-day window? I mean, they haven't complied to this point. Maybe
I-
a shorter window with a fine earlier would motivate them faster?
I think we're well within our right to change the time, just speaking from experience with preparing documents signed and sealed, especially if they were not provided originally. They're behind the eight ball trying to get this done. And any undue pressure, just like the GC, we're trying not to go after his license because he came into this late. You're putting pressure on an engineer that's coming in to try to rectify. And then you also have the unknown, which is the city review time for those comments.
That makes sense.
So I would be agreeing with the 30 days.
I would too, based on the general contractor. Late to the party. All right, any other comments or questions, concerns? Christian, roll call, please.
Board Member Gallo.
Aye.
Board Member Capra.
Aye.
Board Member Pankey.
Aye.
Vice Chair Martin.
Aye.
Chair Gilday.
Aye. All right, that brings us to item 501.
For the record, Chris Elbon, Code Compliance Inspector at the City of Winter Springs. I have been sworn. I request this presentation and testimony be submitted as part of the official record. Next agenda item to be heard is case number 2025-CE000376 for the property located at 606 Casa Park Court A for a violation of Florida Building Code Section 105.1. Permits required. Again, under Florida Building Code Section 105.1, permits required as listed. Case summary, on March 3rd, 2025, I conducted an inspection of the reference property based on information provided by Phil Bauer, Winter Springs Construction Inspector, regarding unpermitted construction alteration of the property being performed at the reference property. I observed not only a dumpster outside containing various construction debris, it also contained insulation, drywall, and a water heater. I conducted a permit check, which revealed they only had an active permit for electrical under permit number residential 2025-2914. I posted a stop work order at the reference property, exhibits 1 through 7. Exhibit 1, the property with the dumpster outside. Exhibit 2 with the construction debris. There you have the water heater in the back there. Exhibit 3 there. Exhibit 4, the door was open and you could see inside that there's drywall throughout the property. Exhibit 5. And Exhibit 6 of the stop work order posted. And Exhibit 7. On March 3rd, 2025, notice of code violation was sent to the property owners by USPS certified mail with return receipt requested. On March 31st, 2025, notice of code violation was returned to the sender. On April 2nd, 2025, I posted the notice of code violation at the reference property and at City Hall and executed an affidavit of service. Exhibits 8 through 9. That's Exhibit 8 of the notice of code violation posted at the property. And Exhibit 9. On May 5th, 2025, I conducted a permit check which revealed that a permit for alterations had been issued on April 16th, 2025 under permit number residential 2025-3244. On May 28th, 2025, I was informed by Glenn Perino, our building official, that the permit residential 2025-3244 for alterations had a hold placed on it, and permit residential 2025-2914 for electrical also had a hold as an expired permit. On May 30th, 2025, notice of hearing was sent to the property owners by USPS certified mail with return receipt requested. On June 27th, 2025, notice of hearing was returned to sender. On June 30th, 2025, I conducted a permit check which revealed that permit number residential 2025-3244 for alteration remains on hold, and permit residential 2025-2914 for electrical remained on hold. On June 30th, 2025, I posted the notice of hearing at the reference property and at City Hall and executed an affidavit of service. Exhibits 10 and 11. So Exhibit 10 of the notice of hearing posted at the property, and Exhibit 11. On July 10th, 2025, I conducted another permit check which revealed that permit number residential 2025-3244 for alterations remained on hold, and permit number residential 2025-2914 for electrical remained on hold. And as a follow-up, on July 21st, 2025, I conducted a permit check which showed that permit number residential 2025-3244 for alterations is being issued, and permit number residential 2025-2914 for electrical is also being issued. So in this case, staff recommendation, staff recommends the Code Enforcement Board find the property in violation. Correction here. There we go. Staff recommends the Code Enforcement Board find the property in violation and issue an order establishing grounds for a repeat violation in the event this violation reoccurs within the next 5 years.
Chair.
Go ahead.
On Exhibits 10 and 11, there seems to be an additional document posted on the structure. Is that a permit receipt that I'm seeing on Exhibits 10 and 11?
Yes.
And do we know which permit that was, and was that
So that
your
would,
posting, or was that them posting?
no, that would have been the electrical, that was on a hold at that time.
On
And-
hold, or it was expired?
It was, according to the permitting, it showed on hold and expired.
Okay.
For clarification, did you post that, or was that posted in response to all your other postings when you were there for the inspection?
No, that was already pre-existing. I did not post that at the property.
So that seems to be a response. Do we have a record showing if this is a hold or a review?
So as of now, they have been issued. Both permits are issued.
But there's a hold.
Not as
No.
of
The
the
tw-
21st.
As
July
of the
21st.
21st, they were issued?
Correct.
So you're looking to just, in case we have a repeat offender situation?
Correct.
Okay. I understand. Thank you for that clarification.
Inspector, at some point, you gave them a date to comply,
Yes.
and what date did you give them?
Let me go to the notice of, let's see, the notice of violation here. It's in the agenda item. So initially, let's see, it was June 1st, 2025 was
Okay.
when it was reposted. The one that was mailed out would have been, okay, it also appears, so June 1st, 2025 to
Perfect.
apply for and obtain the permits.
Thank you.
So to sum up, they weren't in compliance. At some point, they got notified and they came into compliance. And they're in compliance now, but we just want to get something on the record for those days in June, whatever, that they were not.
Correct.
compliant.
It was predicated with only having a permit for electrical, but the property was going beyond that with water heater, which would require plumbing, and the drywall, which would have required alteration. So they went beyond the scope of the electrical permit. And at some point, that permit got a hold and expired. They were required to get the alteration permit. So now they've applied for both and they're issued.
Good.
Any other questions? Pretty straightforward.
Has the respondent is not here, is that correct? I don't
Correct.
see anybody sitting out there. Have they tried to work with code enforcement?
The only time I've had any contact with either it was a property owner or someone residing at the property was the initial inspection when I posted the stop work order and notified that work had to stop and permits needed to be applied for.
Okay, so at some point, they took action.
Correct.
Okay, thank you.
Welcome.
Anything else? Oh, your motion?
Yep, Mr. Chair. Yeah, I move to find that based on the photographs and the testimony from the inspector and the evidence that was submitted to us, that there was, that the respondent violated section 105.1 of the Florida Building Code, permits required, and failed to correct that violation by June 1st of 2025, the time that the code inspector gave for correction, that the violation is currently corrected and that no fine be imposed.
for the legal, do we have to go on and state that in the event that the violation?
No, that would
No,
be in
no,
the order.
yeah, we don't need
You
anything
don't have
else
to
in the
say
order.
that. Yeah,
Okay,
thanks.
thank you.
I'll
Any-
second.
Okay, any discussion? Christian, roll call.
Board Member Gallo.
Aye.
Board Member Capro.
Aye.
Board Member Penke.
Aye.
Vice Chair Martin.
Aye.
And Chair Gilday.
Aye. All right, that brings us to item 502.
For the record, Chris Albon, Code Compliance Inspector with the City of Winter Springs. I have been sworn. I request this presentation and testimony be submitted as part of the official record. Next agenda item to be heard, case number 2025 CE 000751 for the property located at 1054 Winter Springs Boulevard for a violation of Florida Building Code Section 105.1, permits required. This is Florida Building Code, Section 105.1, permits required. Case summary, on April 29th, 2025, I arrived at the reference property based on information forwarded from Community Development regarding construction alteration being performed at the reference property without a building permit. I conducted a permit check which revealed only an active permit for a roof under Residential 2025-3284. I observed electrical work being performed within the interior. I posted a stop work order notice at the reference property, exhibits 1 through 6. This is exhibit 1 of the inspection. So the work being performed with the permit is right now just for the roof. Exhibit 2. Exhibit 3 with our unlicensed electrician. Exhibit 4. Exhibit 5, the stop work order notice. And Exhibit 6. On April 29th, 2025, notice of code violation was sent to the property owners and registered agents by USPS certified mail with return receipt requested. On May 27th, 2025, notice of code violation was returned to sender. On May 22nd, 2025, I posted the notice of code violation of the reference property and at City Hall and executed an affidavit of service, Exhibit 7 and 8. Exhibit 7, the notice of code violation posted at the property, and Exhibit 8. On June 9th, 2025, I conducted a permit check which revealed that a permit for electrical had been applied for on May 28th, 2025 under permit number Residential 2025-3594, but had not yet been issued. On June 9th, 2025, notice of hearing was sent to the property owners and registered agents by USPS certified mail with return receipt requested. On June 12th, 2025, that notice of hearing had been delivered. On June 18th, 2025, I conducted a permit check which revealed that permit number Residential 2025-3594 for electrical had not been issued, or had been issued, correction, on June 17th, 2025. On July 10th, 2025, I conducted a permit check which revealed that the permit Residential 2025-3594 for electrical had been completed with a final inspection on July 10th, 2025. Staff recommendation, staff recommends the Code Enforcement Board find the property in violation and issue an order establishing grounds for a repeat violation in the event this violation reoccurs within the next 5 years. That concludes my presentation. Does the board have any comments or questions?
Chair?
Yes.
Just to, on the record question, you gave the notice of code violation, and they had until June 1st, 2025 to comply. Permit was not approved until June 17th, 2025, so a total of 16 days in violation.
It appears that way.
Thank you.
Inspector, I have a question. In your testimony, you said an unlicensed electrician?
Yes, when I spoke to the owner agent, because it's owned by an LLC, I did inquire about the electrician. Said he wasn't licensed, it was just a buddy of his that knew something of electrical.
As odd as that is, he did have a final inspection.
Oh, no, no,
So afterwards, they
I realize
did
that.
hire a licensed electrician to submit the permits and
Okay.
get the inspections and make sure the work was to code to pass that final inspection.
Okay.
It sounds to me, he didn't have a permit. You caught him, then he got the permit,
Correct.
and he was not in compliance for some number of days in June. And now we're being asked to, he's in compliance, so I guess it's more for a legal question, is a no fine seems to reward trying to get around the system, I guess, is what I'm thinking.
I can't speak to what their motivations might be, but given that they are in compliance, we can't impose a fine today.
I think a point of clarification, since this is recorded and it's a public meeting, I've had in the past people point to a clause in the Florida Building Code. It's a specific chapter 501.2.2 minor repairs. This is specific to ordinary minor repairs being in an emergency case, minor patchwork, replacing in kind. That definition, which is public information, I'm not going to read it verbatim because it's available to the public, clearly states that if you have to replace things like electrical wiring, plumbing, mechanical equipment, if you touch a wall, cut open a wall, you need a permit. It clearly states that those do not constitute minor repairs. So just for board's edification and for the public in general, if you're looking to do any work in the house and you're looking to replace anything as equipment or cut a hole in a wall, you need a permit.
Thank you for that.
Yeah, thank you. Where I was coming from, in case I wasn't clear, was, it seems in this case, the respondent didn't get a permit and only got a permit because he was caught, and now he's in compliance. So I just feel that he found a loophole in the system where you have a way to try to get around a permit, and you'll either get around it without getting a permit, or you're in this case where he's in compliance and there's no fine.
You're correct. He was caught. We did not have an opportunity to hear this until he was in compliance. So we're in a situation here where we can't do the, we can't administer a fine. However, we can go on record
Yes.
and have a motion so that in the event that he tries these shenanigans in the future, that he's a repeat offender then, or it's a repeat issue.
Yeah,
So
no,
that's what we're trying to
I
establish.
Yeah, I understand. I know we're just following the process, and I'm good with that. I just wanted to comment on the record that, here's an example of someone that tried to get around the system and might well have done it, but he wasn't lucky enough. That's all.
Noted.
Okay.
Does anyone want to take a shot at the motion here for me?
I'll take a shot.
There you go.
I move that the photographs and testimony for Officer Elbon be, show there was actual violation of Florida Building Code, Section 105.1 on June 1st of 2025, was corrected and came into compliance on June 17th of 2025. Therefore, no fine be made as they have come into compliance.
Do I hear a second?
Yeah, I'll second.
Any other comment, concerns, questions? Christian, roll call, please.
Board Member Gallo.
Aye.
Board Member Capra.
Aye.
Board Member Penke.
Aye.
Vice Chair Martin.
Aye.
Chair Gilday.
Aye. All right, and that brings us to item 503.
For the record, Chris Elbon, Code Compliance Inspector at the City of Winter Springs. I have been sworn. I request this testimony and presentation be submitted as part of the official record. Next agenda item to be heard, case number 2025 CE 0001142 for the property located at 224 Shore Road for a violation of IPMC Section 304.7 roofs and drainage. Under IPMC Section 304.7 roofs and drainage, the roof and flashing shall be sound, tight, and not have defects that admit rain. Roof drainage shall be adequate to prevent dampness or deterioration in the walls or interior portion of the structure. Roof drains, gutters, and downspouts shall be maintained in good repair and free from obstructions. Roof water shall not be discharged in a manner that creates a public nuisance. Case summary, on January 21st, 2025, I observed that the roof of the reference property failed to be maintained sound, tight, and without defects, as evidenced by the tarp on a portion of the roof, Exhibits 1 and 2. This is Exhibit 1 for the property located at 224 Shore Road. There's the tarps and sandbags up on top, and Exhibit 2. On January 21st, 2025, a courtesy notice was sent to the property owner by USPS regular first-class mail. On February 24th, 2025, I conducted a reinspection of the reference property and observed that the property remained in violation. Exhibit 3 saw the tarp on the roof. On February 24th, 2025, notice of code violation was sent to the property owner by USPS certified mail with return receipt requested. On March 24th, 2025, the notice of code violation was returned to sender. So on March 25th, 2025, I posted the notice of code violation at the reference property and at City Hall and executed an affidavit of service. Exhibits 4 through 6. Exhibit 4 of the property. Exhibit 5 of the notice of code violation posted. And Exhibit 6. On May 28th, 2025, I conducted a reinspection of the reference property after posting that notice of violation and observed that the violation remained. Exhibits 7 through 8. This is Exhibit 7 of the reinspection with the tarp remaining on the roof, and Exhibit 8. On May 28th, 2025, notice of hearing was sent to the property owner by USPS certified mail with return receipt requested. On June 23rd, 2025, that's a typo, it should be notice of hearing returned to sender. On June 23rd, 2025, I posted the notice of hearing at the reference property and at City Hall and executed an affidavit of service. Exhibits 9 through 11. This is Exhibit 9 of the notice of hearing posted at the property. And Exhibit 10. And Exhibit 11. Staff recommendations. Staff recommends the Code Enforcement Board find the property in violation, issue an order requiring the violation to be corrected, and the property brought into compliance on or before October 20th, 2025, which gives the property owner 90 days to secure a permit for the roof repair, and consider an imposition of a daily fine of up to $250 per day in the event the requirements of the order have not been met by the date set for compliance by the Code Enforcement Board. That concludes my presentation. Does the board have any questions?
Any communication with the respondent?
So on Friday, the respondent emailed requesting an extension for 90 days. I advised the property owner that we've given due process and kind of exhausted the extensions at this point, and it's going to move forward, and the recommendation would give that 90 days for the extension to obtain a permit.
Is the respondent here?
The respondent is not.
I have a question for Ms. Ulmer. I just happen this address looked familiar to me, and I happened to look back at my notes, and this case was on an agenda back in 23 January 2024,
Okay.
but it was pulled.
Okay.
And my feeling is, and I have no evidence to back it up, but my feeling is that it was because it was pulled so the respondent could work with code enforcement. So I suspect that this should have, I don't know if this has any bearing today now that it's come up again, the same address with the same issue that I have from my notes from January of 2024. So I'm asking for some legal advice there.
Sure. I mean, you have that knowledge, so you can take it into consideration in determining maybe the amount of the fine or how long to give to compliance. But really, the issue before us is, as first noticed, I think in January 2025, and then first noticed as in seen, and then as subsequently noticed, and before you today with the request for the 90-day extension in addition.
Okay, so I can consider that.
You can, I might recommend, I mean, it's hard to not consider something that you already know. I might recommend focusing on only the evidence presented today, but
Okay.
No evidence was presented in January 2024.
right.
We
Because
can
we pulled it.
theoretically fix that. I have a question of Deputy Chief. If the Deputy Chief, can you go back and take a look at January of 2024 and tell us what the violation was and why it was pulled,
I can attempt to do that.
please?
Yeah. Let me grab my computer.
Thank you.
Yeah, the date I have is 23 January 24, agenda item 500. And I believe we'll find it was pulled.
So, as a word of caution or recommendation, just to keep on the straight and narrow for the legal aspect, I would recommend just looking at the evidence as presented today for this case alone, because this is the only case being presented, not any other case.
Correct, Inspector, but however.
So I can't speak on
No,
behalf of
I'm-
any
I'm-
other case.
I'm not asking you to speak on behalf of any other case. If in fact, in 2024, if in January of 2024, the issue that was brought to the board or there was agended and pulled was roofs and drainage, then then it's essentially the same deal. And I would consider that to be that they've had well over a year to repair this thing, and that then plays into how we would deal with it as far as time is concerned.
Yeah, that's.
My only word there of caution, sorry, Art,
No, go-
but we would know that the address was brought up before us, but we don't know if it's the same respondent. We don't, unless we
Well-
go into further discovery to
Right,
see
right,
who
but-
it
but-
was.
But that's exactly what the deputy chief can tell us.
I would recommend only discussing the case as presented, because the property owner has not been notified of any other case being brought before the Code Enforcement Board, which may be a due process violation.
From my perspective, I understand that, but this would, she's asking for three more months extension, is what I heard you say, correct?
And
Okay.
the recommendation is 3 months to obtain a permit.
Say that again?
The recommendation for correction is to allow for up to October 20th, 2025, which would give 90 days to apply for and obtain a permit. So the event the permit is secured on or before October 20th, 2025, they can do the work under that permit without being fined, but they would have until that day to obtain a permit.
Off of the current line of questioning,
Okay.
your communication, and I'm sorry to change it, I'm just curious, with that 90-day request, was any reason given? Is she waiting on an insurance or anything like that, or she just, or he? I don't know.
The property owner, she didn't give really too much of an explanation on, apparently she was concerned about getting any fines being imposed.
Okay.
But I advised that it's not going to be fines imposed today, it's giving more time for compliance before fines are imposed.
So
And that's
she-
why he recommended the 90
Yeah,
days.
the 90 days, that would help her, give her time to get the permit?
It would give a reasonable amount of time, which is similar to not only what the property owner was requesting, but previous cases that the Code Enforcement Board has made recommendations for timelines for roof repairs. There's been time given to obtain those permits.
Okay.
Consistent with other situations. What did we find?
What I can tell you is, obviously what Inspector Elbon advised you is correct as far as due process and not getting into the previous case. It had to do on our end of not being prepared for the case due to employee turnover.
Okay. Thank you.
Okay.
Any other questions? I'll hear a motion.
Then I move to find that, based on the photographs, testimony from the inspector, show that there are sufficient findings that the respondent is in violation of IPMC Section 304.7. That's based on the tarps that are on the roof, and there is no permit at this point for roof repair, and that she be given until, the response be given until October 20th, 2025, to make the corrections in the event that the violations are not paid by that date. A fine in the amount of $250 per day shall be imposed until compliance is reported to and verified by city code enforcement.
Do I have a second?
I'll second.
Any other conversation? No? Christian, roll call, please.
Board Member Gallo.
Aye.
Board Member Capra.
Aye.
Board Member Penke.
Aye.
Vice Chair Martin.
Aye.
And Chair Gilday.
Aye. All right, that brings us to the end of cases. Does anyone else have any issues, items, concerns, questions we need to speak about, or? Nope. All right.
Oh, wait, I do, sorry.
Go ahead.
I just wanted to say, this is my last meeting, so I wanted to say thank you for having me for the last 18 months. It's been a pleasure working with everybody. I've enjoyed serving, but I'm not staying. So I will come visit, though.
Well, thank you for your
So
service.
I've learned a lot. You guys have a lot of knowledge, and it's been really interesting. You guys do amazing work. I know you're not probably like welcomed with open arms when you go to people's homes, so I, as a citizen, appreciate what you guys do. I'm sure it's not the easiest task, so I thank you.
Thank you.
Thank you for your service. Thanks for the comments.
Yeah, we will miss you.
Thank you.
You found a replacement? You know it's up to you, right?
I offered some names up. Yes, I did.
All right. This meeting's adjourned. Thank you.
Thank you.
Appreciate it, guys.
Thank you.